Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. This series is for all of us to move further on our journey toward learning about the Constitution and also toward justice. But it's especially for my students who I'm teaching remotely this semester, just to give them a little something more on these topics. Now, let me go back to say, I'm a professor at Mississippi College School of Law, but all explanations here are my own, and they are not to be ascribed to the school or to my students. Now, with the First Amendment, can you believe a little bitty amendment like that and all of this case law that we're talking about and we're going to talk about throughout this semester? But our general rule, generally, pure speech is protected from content regulation by the government, unless, and there are several unlesses, but the one we're focusing on is unless the speech is in an unprotected category. If it is in an unprotected category, government has more leeway in terms of regulating that speech. The first unprotected category we talked about was speech that advocates illegal action. And in the last two clips, we talked about, as an unprotected category, defamation and defamation public disclosure of private information, all of that grouped together in terms of categories, a category of unprotected speech. And now we're about to talk about another category of unprotected speech, obscenity. Now, what we're going to do here, I'm going to give you a little hypothetical. It's actually from an actual case. Then I'm going to tell you what the court has said, how the court defines obscenity. And then we're going to go back to the hypothetical I gave you and ask you, how do you think it should turn out? Before we do all of that, I want to tell you that the hypothetical I'm going to tell you about is from a case I actually had the opportunity to work on as a law clerk. It's a wonderful opportunity to get to serve as a law clerk while one is in law school or recently graduated, especially a law clerk for a judge. So I clerked for Mississippi Supreme Court Justice Fred Banks my last year of law school. I didn't get paid, I got school credit. He called me a half a law clerk. And then I had the opportunity to clerk for the chief judge of the Fifth Circuit Court of Appeals, federal judge, Judge Charles Clark, who is now passed away. And I also had the opportunity to clerk for a senior judge who was a former chief judge of the 11th Circuit Court of Appeals, also a federal judge, Paul Roney, who is also passed away. Now, it was while I was clerking for Paul Roney, Judge Paul Roney, that I had an opportunity to work on an obscenity case related to one of the sheriffs in Florida, and also a musical group. I don't know if you've heard of them, Two Live Crew, and one of their albums called As Nasty as They Wanna Be. Now, when I clerked for Judge Roney, we had a whole staff of people along with the judge. There was Estelle, who was so marvelous to all of us, and she was the judge's assistant. And also I clerked with two other law clerks. We gave each other Southern nicknames. I don't know, maybe they were picking on me, given that I was from Mississippi. Shelley Lee, a former athlete, football player, all of that, very intelligent and like a younger brother to me. And also Lizzie. Lizzie was so kind and wonderful and intelligent and like a sister to me. So I won't use their real names. We don't want to be calling them out on YouTube. So the Chambers had this case that they were trying to resolve. And the judge came to me one day and said, Angela, I want you to work on this case. Here's the file. It's about obscenity. But I want you to remember one thing. An opinion about obscenity does not have to be obscene. Then he said something really interesting. He said that this case is about an album, as nasty as they want to be. He said, but I don't think you should listen to it, Angela. You know, this is locker room talk and everything. I know Shelley Lee listened to it. But you know, he played sports and he and Lizzie are so much younger than you. I was 35 and they were younger, much younger. He said, I don't think you should listen to it. It may not be good for you to hear these types of lyrics. So I said, okay. So I opened the file and started to look in the file. And the case had been before the court for a while, with the court trying to decide what to do with it. And in the file, some of the other judges, they had their law clerks to transcribe and write out all of the lyrics. And wow, those lyrics were something else, even to see them in print. I'm more so from the music of the, you know, the old school, the soul music and all of that. So this, it was something to read. So what happened was Two Live Crew, they had this song, this album with rap music, and the sheriff of one of the counties, he wanted all of the albums removed from the shelves. So he said, you know, take these albums off the shelf. This music is obscene. So, of course, the store owners complied, but Two Live Crew, Luke Records, they filed suit, make the sheriff stop doing this. They want to sell some music. So it all boiled down to, was the music, was the album as nasty as they want to be? Was it obscene? If it was indeed legally obscene, then the sheriff, the government had more leeway in regulating it. If it was protected speech, well, it's going back on the shelves. Now, of course, you know that as soon as the judge went away for a few days, my co-clerk, Shelley Lee, came to me and said, Annie Mae, how are you going to help with an opinion and you haven't even heard the music? I told him what all the judge said, et cetera, et cetera. He said, you got to listen to it or else you're not going to be giving it your best input. So as soon as the judge went away for a while, we went in the library, took out the album, set the music up. I don't remember if it was a record or a CD, and we gave it a listen to. And let's just say it was indeed something else. So the court was struggling with whether or not the music was obscene. We discussed some very interesting things in chambers and with the judge. Like, let's say that you have some lyrics that may be rather provocative. Okay, they may be suggestive or provocative. If those words are put to music, does the music make something that is provocative less provocative? Does the music give it, I don't know, more class? Or does music add it to something that is already provocative? Look at me doing a little dance step here. Already provocative. Does music make it more obscene by the emphasis the music adds to it? So we looked at all of these issues in trying to decide about this album. Now, when the trial had happened, I clerked for the Court of Appeals. A trial had already occurred in the federal district court. When the trial had happened, the sheriff, the only evidence the sheriff put on it all, the only evidence, and the case was tried before a judge, not before a jury. The only evidence, the sheriff took the album, he put the album into evidence, and he said, that's all I need. That's all I need. Listen to this, he said to the judge, and you will agree with me that it is obscene. Now, Luke Records and Two Live Crew, they were a little more extensive in their evidence. They talked about, I don't know if you've ever heard of the call and response tradition. Now, in the times when I've talked about call and response, we talk about what we do in church, and especially in your predominantly Black churches or your missionary Baptist churches, where a speaker will say something and the audience replies back to them, talks back to them. Look, in class, I tried to get my students on Zoom. I'm like, talk back to me. Let me know you're in the room. I don't know. I don't know if they get it. Maybe after they watch this clip, they'll know what I'm talking about. So Two Live Crew talked about the call and the response tradition that was in the African-American tradition and also just in the Black tradition and from Africa. Two Live Crew also put on other evidence talking about some other things in the style of the album that carried over from Africa, talking about the artistic creation that it was and the type of history that, as nasty as they want to be, spoke of. So the trial judge determined that it was obscene. And so now the case is before the 11th Circuit Court of Appeals with my judge, Judge Roney, and I'm assigned to, read the file and give some suggestions, give a draft to the judge in terms of how the court can resolve the matter. So let's put a pig there, as my grandparents would say, and let's look now at what has the court said about obscenity. Now, the court said that obscenity is unprotected speech. And I've given you some citations at the bottom of the page that would tell you more about some of these cases. And even though the court said that obscenity is unprotected, the court has struggled with how to define obscenity, for there to be fair notice, and so as not to chill speech. We have to have different types of rules. We have to give direction to the states in terms of what types of laws they can fashion. So the court said they know that obscenity is unprotected speech, but they struggled with how do they describe what obscenity is. And in one case, the court said obscenity does not add anything. to the exposition of ideas. It only has slight value as a step to truth. Sort of doing a take on the marketplace of ideas theory. Remember that from the Abrams dissent by Justice Holmes. Now, the court also said in some earlier cases that sexually explicit pornographic material is not necessarily obscene. So something could be pornographic, but not legally obscene, according to the court. When there's a conclusion that something is obscene, you're saying that it is legally obscene under the current tests that the court has articulated. Now, it was some very interesting cases I mentioned down at the bottom. One case was Stanley versus Georgia. So a man was he had some material in his home that was determined to be obscene material. So can he be prosecuted for having obscene material in his home? And the court ended up saying something like, a man's home is his castle, something like that. And so therefore, he could not be punished for having certain obscene materials. And I say certain because we're going to, in the coming week, we're going to add a twist to this, certain obscene materials in his home. But then the court, they kind of went back and said, yeah, you can have it in your house, but you can be prosecuted for sending it through the mails. You can be prosecuted for the sale of certain material. So therefore, getting into your home may be quite difficult. But the court said once it's there, then perhaps it's a different matter. Now, in one case about an adult theater, Paris adult theater, there were some principles from that case that were quite important too. The court talked about why would a state want to regulate obscenity? And basically, the court says, well, a state may be concerned about morality or decency. The state may want to protect a viewer, protect you from your own self, that looking at the material could make you more depraved. But the court also talked about that if there are signs or depictions in public or on the streets, then there may be non-consenting adults who don't want to look at that, or there may be children around. And so therefore you have to consider all of that and determining whether a given publication is obscene or not. Look, Justice Stewart, he said something, and then later on, he said he really regretted having said it, that they probably would put it on his tombstone. Justice Stewart said that, he said, I'm looking for the exact quote. He said, I may not can describe it, but I know it when I see it. Okay, we think that's really funny in the law. And so that gets repeated all the time, that you might not can describe it, but do you know it when you see it? That's what Justice Stewart said. Now, all of those are just principles about the things that the government or the court is taking into consideration as it evaluates this material. But in a case called Miller versus California, and I have the citation at the bottom with the name and the date at the bottom, the court came up with this three-prong test, okay? The first part of the test is, and look, all three parts of the test must be met for the material to be considered legally obscene. First, the court said you ask whether the average person applying contemporary community standards would find the work taken as a whole appeals to the prurient interest. Now that's a whole lot. So first of all, it has to be the average person. How would the average person look at this? And the court said the average person is not the most prudish person, but it's not the most out there, so to speak, person. Applying contemporary community standards, not the standards from 1950 maybe, but contemporary community standards. Then you take the material as a whole. So the material may have, a movie may have one scene in it. It may have a steamy shower scene, perhaps, but you have to take the work as a whole to determine whether or not the work is obscene. And we're still on the first part of the test, whether it appeals to the prurient interest, prurient, prurient interest in sex. The court says there's a normal interest in sexuality, and then there is a depraved interest. And so whether or not the work appeals to that prurient, depraved, shameful interest in sex. So that's the first factor. The second factor is this: whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. Now, in our book we use in class, of course, it goes through lots of examples, the actual case, what types of depictions. And let's say the language in this case is quite specific. It is so specific that I'm not going to repeat it here on this YouTube channel. But you can Google Miller versus California and read about that for yourself. It's very specific in terms of the type of depictions that a state can make unlawful. And then the third part is whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So it could be something that appeals to the prurient interest, and where the state can prescribe it by law. The state can say that it's patently offensive by law, but it may not meet number three. It has to also meet number three. Does it lack serious literary, artistic, political, or scientific value? So look, I remember my first year of college, I was in an honors biology class, and a couple of my friends, the teacher used to pick on us. He thought we were rather unsophisticated and called us the Three Stooges or something like that. But we were sitting there, this 600-page, it looked like biology book, just sitting in class, flipping through it. And I think it was me. I may have been just a bit mischievous. I think it was me. I flipped to a page and oh my goodness, I had never seen anything like that. Oh, wow. And I told my friends, look at page such and such. And all of a sudden, everyone is turning to the page and we're going, oh my goodness, oh my goodness. Maybe that's why the teacher called us a silly name. But anyway, that material, even though it may appeal to a prurient interest, it may show depictions that are described by state law as being obscene. It had a scientific purpose. It appeared in a biology book, and it was making some points, some discussion about human reproduction. or the work could have serious literary value, artistic value. When I first started traveling, I always enjoy museums, but I just couldn't get over it when I went to a museum. I think it may have been in New York, and there were all of the statues of the nude bodies. And I was younger then, but I would look at some of the older people who would just be standing there staring and discussing it. And I just thought, oh my goodness, they were discussing the serious literary, or not literary, artistic value of the state. Okay, you all, let me stop. Now, the court said these are the prongs. These are the prongs. But then the court said something else. So we have this national, these are the three things you look at to determine if the material is obscene. But when you start reading through these factors, you see that one state may believe something is obscene that another state may not. So we have a national test, but the application of the test may vary by the region. And the court said, that's okay. The court said something like, this is a national test, but, and I'm reading from the opinion, the court said what is obscene in Maine or Mississippi, according to the court, may not be considered obscene in Vegas or New York. I mean, I understand the court's holding, but then we do not have one national idea about what is obscenity, as it gives certain leeway to the states. You think on that and whether or not that's a good way to interpret the First Amendment. So now that you have the test with these three factors, and again, these three parts, these three prongs that are also noted in the text below this video. Now let's go back to the Luke Records case. What do you think the court held? Now, the court could have said this speech is obscene and unprotected. The court could have said that. The court could have said this speech is not obscene. Therefore, it is pure speech and is protected unless the government meets a high level of review. The court, and there were three judges, I believe, on the panel, they ended up, I put it that way, doing neither of those. What they ended up holding was that the sheriff did not meet his burden of proof to show that it was obscene. I'm like, what is that saying? The sheriff did not meet his burden of proof to demonstrate that the material was obscene. So maybe in a different case, it could be shown to be obscene. Maybe the sheriff didn't meet his burden of proof because it was not obscene and it's pure speech. All the court held was the sheriff did not meet his burden of proof to show it was obscene. See, he only put the record in. He only put the album in, as nasty as they want to be. So even if it met parts 1 and part 2 of the test, even if you could determine that, how do you deal with part 3 about the artistic value of the album? Two Live Crew had put in several different experts to give testimony about some of the style of the music coming from the African and the Black tradition and all different types of things. But the sheriff just said, listen and figure it out. So the court ruled that the sheriff did not prove it was obscene. Therefore, then the records must go back to the sheriffs and could be sold even in that county in Florida. I've given the name of the case there. You can check it out and read it for yourself. So, wow, think on all of that. We're going to come back to the topic of obscenity later on. The court has something they call near obscene. It's not quite meeting the test of obscenity, but the court wants to allow more for regulation of it. Then the court has considered speech that may not be legally obscene, but that it has depictions or performances, depictions of children. And so then the court says, we got to do something different with that. And we'll be talking about those cases in the coming weeks. For now, this is your introduction to obscenity. Remember, learning about the Constitution, learning and critically examining things for yourself is part of enlightenment. And enlightenment is a step toward freedom and freedom toward justice. My goal here is to bring you at least a taste of justice. I'll be back in probably about a week and a half to talk about more categories of unprotected speech. For now, subscribe and sign up for notifications so you won't miss a thing. Bye.